A very good morning to you, and welcome to today's webinar, a popular topic that we offer on a quarterly basis here, Trustee Selection, How to Choose the Right One for You, presented by Elville & Associates Managing Principal and Lead Attorney, Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville & Associates, and I'll be moderating today's event. So how this will work today, if you're new to our webinars, if you are, welcome. We're glad you're here. And if you're returning, welcome back. So you as the attendee are in listen-only mode. However, if and when you have questions, please note them in the questions panel on the right-hand portion of your screen, and we'll take time throughout the presentation to address them. As always, your questions really help the presentation and add value. They help others learn. So please don't be shy in posing your questions at any time. You should have received the presentation yesterday by email from me to take notes on it if you wish. If for some reason you did not receive the presentation yesterday, it is available in the section marked Handouts in the panel on your screen to download at this time. For CFPs, CPAs, and various other professionals on today's webinar, you may receive 1.5 continuing education hours for attending. Per attendance records requirements on my end, please email me your ID number, and for CFPs only, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CE hours for approval. Everyone will also receive a post-webinar feedback email right after the presentation, and we ask that you please just take a couple minutes to fill out this simple survey to offer us your feedback about the presentation. We read and value every comment that you submit. It's also an ideal time to request a consultation with Steve for planning needs that your family and you may have now or in the future. And here at Elville & Associates, we look forward to being a resource to you now and in the future, always with our 8 ideals of client education, collaboration, and compassion in mind. So briefly, I'd like to offer you a brief overview of Elville & Associates and Steve, and then we're going to start off with a brief poll, and then we're going to jump right into the presentation. So Elville & Associates, we were founded in 2010 in Columbia by Managing Principal and Lead Attorney Stephen Elville. We offer a number of different practice areas for our clients here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection. We have 7 attorneys, 12 staff members, and 5 locations, and Steve and I are coming to you live from the Columbia Gateway Community location today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. We do offer a lot of education here at Elville & Associates for those of you that know us, and we do this in several ways. Through our planning processes with our clients, we offer over 100 educational webinars and workshops in the communities we serve each year, and also by way of our accredited client care program, or CCP as we call it here. We're one of only 2 firms in Maryland to have an accredited CCP through the Client Care Academy in Boston. And again, we always work here with the ideals of client education, collaboration, and compassion in mind with every client, every time, every day. A little bit about Steve. His work as an attorney for the past 20 plus years has been centered in, oh, I lost my screen, where'd it go? There we go, no, a minute. Sorry about that. Has been centered in elder law, special needs planning, and estate planning with an emphasis in the areas of tax planning and asset protection. As a member of the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys, he works to bring peace of mind to clients through counseling, client education, and superior legal technical knowledge. A very seasoned speaker, each year presenting at many workshops for businesses and their employees, conferences, and continuing education events. Also named to the Maryland Super Lawyers list for a 7th time for 2022, so congratulations to Steve. And he also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, our firm's charitable organization he founded in 2014, and I'm privileged to be the executive director of. So if you'd like to learn a little bit more about the Elville Center and how we work to make a musical difference in the lives of children each day, please reach out to me and I'll be happy to share our story with you. So with all that said, I'm going to go ahead and turn it over to Steve, but we're going to start off with a brief poll first to learn a little bit about our audience. Get out of that. And the poll is, what has brought you to today's webinar? I'm going to launch that poll, and your selections are, I'm a grantor, I've established a trust before, I've been or am a trustee of a trust, I'm the beneficiary of a trust, I'm considering establishing a trust, or lastly, I'm an advisor here to learn to better serve my clients. So if you could select the choice that best suits your situation, we can get an idea who's joined us today. And we'll give it just a few more seconds here. And with about 3/4 of the people here having submitted their responses, we have 25% saying I'm a grantor, I've established a trust before, 12% saying I've been or am a trustee of a trust, 4% say I'm the beneficiary of a trust, 35% say I'm considering establishing a trust, and 30% say I'm an advisor here to learn to better serve my clients, which is always a great thing. So thank you for participating. And Steve, I'm going to go ahead and
Thank you.
make you the presenter.
Thank you, Jeff. All right, I'm going to accept that and see if this is where we want to go. And Jeff, I'm going to minimize you and get to my screen, and hopefully you can see the presentation.
I can.
Thank you so much, Jeff. And good morning, everyone, as I get ready to get my full presentation up and running here. Good morning and happy Wednesday morning to you on this rainy, but I will say spring-like morning. And I hope you are well wherever you are. And I thank you so much for spending your valuable time with us here on a Wednesday morning to learn about this very important subject of trustee selection. I also want to thank my good friend and longtime colleague, Jeff Stauffer, for moderating and presiding over this presentation. He's an expert at doing that. And as Jeff mentioned, we are going to be stopping occasionally for questions. So feel free to look at this presentation as an informal type presentation where you can ask questions as we go along, and we'll do our very best to stop occasionally for that. I know this morning you are here for a reason, and thank you for participating in the survey. My job today is to lead you through a discussion to hopefully give you what I might call a mini master class on this subject, which is so near and dear to many of you, no matter what your particular situation is. I also am going to be not only guiding and educating you, but hopefully giving you a path forward to find resources and to be able to further discuss these issues. Before I go any further, I know that we're living in challenging times, and many of you this morning may have a lot of things on your mind about the world events that we've been witnessing over the last few weeks. So I just want to say here at Elville and Associates, we have been affected, as you all have, by the situation in the Ukraine. We do have clients and beneficiaries of trusts that are in the Ukraine right now that their lives are at risk. So we just want to be very, very clear here that we support the people of Ukraine, and our thoughts are with them this morning, as I know they are with you as well. All right, so we're going to proceed now, and for the next hour to hour and 15 minutes, I hope to leave enough time to take your questions further at the end of the presentation. So thank you again for being here, and we're going to go ahead and start. So what we're going to discuss today is what is a trustee and what are their responsibilities? What are the types of trustees that are available and their characteristics? What are the advantages and disadvantages of the different types of trustees? We're going to get into that. What is the perfect trustee? What is the benchmark that we should be looking at as we think through this issue? What is trustee selection and why is it so important? Now, the plan design. So as we look at different plans and different wills or trusts or whatever the nature of your plan is, what does that design have to do with it? And why is that a difficult decision based on trustee succession and the plan design? What are the different roles that trustees have, both in wills and trusts? And what are some of the reasons why we should appoint a corporate trustee? Some of you are thinking about that issue, an independent corporate type trustee. And why should we be concerned about risk? What is the risk in our succession of trustees into the future? So let's get right into this issue of what is a trustee and what are their responsibilities? Well, much of this may be second nature to you already, so I'm going to be intentionally redundant as we go through this. It's a habit of mine to really be redundant for the purpose of educating and hopefully giving you some substantive points that you can walk away from today. So please forgive me as I go through the presentation. I sometimes have a tendency to repeat myself, but it's also on purpose. So the role of a trustee is to obviously administer a trust. Now, what is that all about? Well, trustees have to follow the terms and provisions of trusts. Now, that may seem like a simple thing. Of course, trustees have to follow the terms and provisions of the trust. But would it surprise you to find out that many trustees do not even read the provisions of the trust? I don't know why this is the case, but it's a pervasive problem. It seems to be human nature to skip over some of these things or to just think we already have read it once, we don't need to read it again. So the trustee has to administer the trust, but by doing so, they have to follow the terms and provisions of a trust. Very simple. Keep accurate records. Account to beneficiaries. Beneficiaries under the law have a right to information. They also have the right to accountings. This is an important thing. I find as I get older that I seem to see a trend that trustees seem to not be accounting like they used to. It used to be a common thing where trustees would account every single year. And I think that's the highest and best thing that trustees should do. But I don't always see that these days from both independent trustees and interested trustees. Make distributions, obviously, and these distributions are either mandatory or they're discretionary according to what? The terms of the trust. The trustee has to make investments. Now, what I see sometimes, which is alarming, is that the trustee themselves, maybe they are just a lay person. This lay person is making trust investments, and that's not what we want. If you're not a professional, if the trustee is not a professional, we don't want them making investments for the trust. We want them to hire professionals to do that. Now, I talked about the beneficiaries being able to get information and they're entitled to information. We also want the trustee to communicate with beneficiaries and find out what their needs are. Make sure that they're getting their questions answered. See, it would be a breach of fiduciary duty for a trustee not to be doing that. So we want to make sure the trustee is in communication with the beneficiaries on a reasonable basis. Now, one of the big issues with trust administration or choosing a trustee is to make sure the tax filings are complete. So we want our trustee to understand their duties and responsibilities about tax filings and manage assets with regard to the income taxation of trust. Now, this is a broader issue that we don't have time to get into today about how trustees should deal with trust taxation. But it is something that we need to understand, that the role of the trustee also has to do with not only the investment of assets, but the management of assets, taking into consideration the income taxation of trusts. All right, so let's get into the basics and definitions of trusts. So a trust is a relationship. It springs from an agreement between the grantor, and I know many of you on this webinar this morning are grantors of trust, but there's a relationship here because you have created a trust and now there's a trustee of that trust. to provide for the benefit of a beneficiary. So the parameters and the responsibilities of the trustee are prescribed within the trust. So this is why we're talking about reading the trust agreement, because it's all in there if it's a properly drafted trust. Standards of distribution, all of that's in there. Now, it may not be 100% clear all the time, and that's one of the problems with trusts overall. Sometimes they're not as clear as they should be. But the standard of distribution and the responsibilities are usually laid out within the trust. Who are the parties? Well, the grantor is the party that creates the trust. Now, in the old days, this used to be called the settler of a trust or the trustor of a trust, okay? The trust maker, so to speak. And so this is the person who's establishing the trust. We're getting really down here into the basics. And then the trustee is the person who is accepting the property. This is the person who says, I agree to accept this property and to use it and manage it for the benefit of the beneficiary or beneficiaries. And of course, the beneficiary is the person or persons for whom the trust is intended to benefit. So they will benefit in different ways. How, when, and what can the property be used for, and so forth. So these are very, very basic things, but I think it's very important to start at the fundamentals. Now, many times, clients or fiduciaries or the public in general will say, I don't really understand the difference between a revocable trust and an irrevocable trust. So let's talk about that for just a second. If you came to an estate planning firm like Elville and Associates or any reputable firm and you said, well, I want an estate plan. Well, that estate plan would consist of a will, if we're talking about basic estate planning, a will or a revocable trust, a will or a substitute for a will. A revocable trust is nothing more than a substitute for a will. So a revocable trust may be amended, it can be modified, it can be revoked. I don't want this thing anymore, I've had it for 20 years. Well, usually that's not the case. We're usually not seeing clients revoke trusts unless those trusts have never been funded with assets, or unless the trusts are no longer needed, or if we have an elder care situation. Sometimes with elder care situations, we will revoke a revocable trust. But usually that is not the case. A revocable trust can be amended or restated or modified. But the issue here is that it can be changed and it is basically taxed to the grantor. So if we create a revocable trust, Uncle Sam does not care about that trust. Why? Because the revocable trust is taxed based on the grantor's social security number. So Uncle Sam says the grantor of that trust pays the tax, okay? But an irrevocable trust, on the other hand, that trust will pay its own tax. It is a non-grantor trust. It can pay and will pay its own tax unless it's structured not to do that. So it is possible to have an irrevocable trust that does not pay its own tax, just like a grantor trust, okay? But an irrevocable trust, generally speaking, cannot be modified, cannot be revoked. However, just like all things in today's world, there are exceptions. So an irrevocable trust can actually be modified today, although the general rule of thumb is that it cannot be. And there are different ways of doing that are allowed, such as decanting or trust protector amendments or a non-judicial settlement agreement or a court modification of some kind and so forth. So we have revocable versus irrevocable trusts. Now, I'm just going to peek at my next slide, but that's not really where I want to go. So I'm going to go back to the prior slide just to give you a few more illustrations. So some people may hear that and it just sounds like a lot of confusion there. So let me give you some examples. I like to think of irrevocable trusts as trusts with a special purpose. A revocable trust, remember, is a substitute for a will. So if I have a revocable living trust plan, that is generally my substitute plan for a basic will. And why would I have that revocable trust? It's because I'm trying to avoid probate. That's my main goal usually. versus a will. But an irrevocable trust is usually a trust I would describe with a special purpose. I have a special needs child, let's say, so I want an irrevocable special needs trust. I have a tax issue and I want to use life insurance as a tool for taxation purpose to pay for taxes or to benefit my family with tax-free income. So I would use a life insurance trust. That's a trust with a special purpose, or a residence trust or a charitable trust. So these types of trusts are irrevocable trusts. And again, for purposes of your thinking about these things, I would look at these as trusts with a special purpose. Now again, the traditional revocable trust is a probate avoidance tool. It is something that is going to provide potential cost savings at death. It is a substitute for a will. Now, back down to the middle or bottom of this slide, we also have trusts for at-risk beneficiaries. Maybe there's a trust to protect someone at your passing, a child, a grandchild, a niece or nephew, or another relation. These are trusts to protect the person from themselves, or because they have substance abuse issues, or they're minors, or they're spendthrifts. And of course, we can hold trust in perpetuity. Maryland is one of those states that allows trusts to last forever. So we can hold trusts in perpetuity for purposes of keeping trusts in the bloodline. We call those dynasty trusts. And of course, the way trusts are structured can depend on whether there is asset protection or not. It is possible to have what we call a beneficiary controlled trust. So as we continue to think through trusts, I just want to take this moment to again go back and try to make sure we're on the same page. We have trusts that are nothing more than will substitutes, like a revocable trust. It can be changed at any time. It becomes irrevocable on our deaths. We have trusts for special purposes like charitable trust or special needs trusts or gifting trusts. Those types of trusts are established during lifetime, and these trusts are irrevocable during life, not just at death. But then at our deaths, we can provide further irrevocable trusts for protection for all kinds of purposes. So there are trusts established during life that are revocable, trusts that are established during life that are irrevocable. There are revocable trusts that become irrevocable at our deaths and have to be administered. And then there are trusts for third parties, trusts for others that can be established at our deaths and are established at our deaths that are irrevocable. In wills, we call those testamentary trusts, trusts established at death. So these beneficiary controlled trusts, these are trusts that can be established during life or at death, many times at death. And through structuring those trusts, the beneficiaries can be given certain control. And these trusts protect against most all creditors, but certain trusts, or all trusts actually, are subject to exception creditors. Uncle Sam, divorcing spouses that are entitled to alimony and child support, those are exception creditors, but generally trusts protect against all other creditors if they are structured correctly. And then there are special needs trusts. There are different types, but these trusts can be revocable during life. They are usually always irrevocable at death, and they also can be irrevocable during life as well. So again, just to reiterate and just to be intentionally redundant here on a Wednesday morning, the trustee is the person accepting the property and manages the property for the person who is the beneficiary. The beneficiary is the person for whom the property is intended. And the trust document tells the trustee how, when, and for what the trust property may be used for the person. Now, as is my habit, we sometimes get ahead of ourselves just a little bit, but again, it's all good. And this slide here talks about something I just mentioned: grantor trusts versus non-grantor trusts. So if you're feeling right now that this is about as clear as mud, you're not alone. So let me try to clarify this for you again. There are two types of trust as far as Uncle Sam is concerned. There is the Grantor Trust, and the typical type of Grantor Trust is the Revocable Trust, the will substitute I just mentioned. And this is the one that is put in place. Many of you on this webinar have this already. This is the trust that allows you to avoid probate. This is the basic Revocable Trust. And who pays the taxes? You do, because the trust is established and taxed under your Social Security number. So the basic Grantor Trust means the grantor pays the tax. Now, if we go beyond the basics, for example, we could have a life insurance trust. Is the life insurance trust a revocable trust? The answer is no, it's an irrevocable trust. But usually a life insurance trust, not always, but usually that is established as a grantor trust. So the life insurance trust is a grantor trust that income from that trust is actually taxed to the grantor. The trust is not paying its own tax. So a grantor trust, like a revocable trust, the grantor pays the tax, even if it's an irrevocable trust of any kind. If it's a grantor trust, the grantor still pays the tax. So the first concept is, in a grantor trust, the grantor always pays the tax. Non-grantor trusts are simply irrevocable trusts. And a good example of this is an irrevocable trust at death for a child or grandchild. That trust is going to be a non-grantor trust. That means that trust has to pay its own tax versus a grantor trust. So there's grantor trust, the grantor pays the tax. Non-grantor trusts, the trust pays the tax. Now, as I mentioned, the trustee, as they are being contemplated by you, who is going to be my trustee, we need to think about their responsibilities. And that's what all of this to this point has been about. And one of those responsibilities is understanding notice requirements. So in 2014, the Maryland Trust Act came out, and this was a very big thing, very big piece of legislation that modernized Maryland trust law. So the Maryland Trust Act basically defines many things, but it basically sets forth the doctrine of the qualified beneficiary. This is a person who is entitled to notice, and your trustee, as you think through this process, this person has to provide notice to the qualified beneficiaries. I'm not going to go through every single requirement, but prior to the Maryland Trust Act, trust beneficiaries were not entitled to notice and all of these things that are we understand now under the law. And they are also able to receive information. So upon request, qualified beneficiaries are entitled to information. And I would argue that this doesn't seem to be limited. Trustees are, for better or for worse, obligated to provide information to qualified beneficiaries, including a copy of the trust agreement. So in Maryland, there is no such thing as what is called a quiet trust. The Maryland Trust Act seems to suggest that there might be a possibility of this, but it is just not there in reality. So qualified beneficiaries are entitled to notice, they're entitled to information, and of course they are entitled to accountings. Jeff, I'm going to take just a moment here and see if there's any questions. I know so far we've just been doing what we do many times, which is laying the groundwork for the bigger, broader information of the presentation.
Thanks, Steve. No questions as of yet. I'm sure they'll be coming though.
Thank you so much. All right, so we're just going to continue on. Thank you for your time and attention. I thought it important to always talk about the role of the financial advisor in trusts and how they relate to establishing new trusts. I offer this information only as you continue to think about the selection of trustees. Again, there is the actual thought process of who my trustee is going to be. We're going to get to that, but we're laying the groundwork here for what are their responsibilities and what are the various roles and things that they're going to be dealing with, in hopes that this will help you as you think through who your trustees are actually going to be. So what is a trustee's job here? Well, their job is to get a new trust account open. Let's say I pass away and I leave trusts for my children, or I leave a trust for my spouse. My surviving trustee has to make sure those accounts are open. If there are multiple trustees, they have to work in concert. So that's a part of drafting, that's a part of designing. We have to have checkbooks ordered. We have to have a debit card perhaps for the account. We have to have a new tax ID number. And the financial advisor is going to be key here. Now, I will just give you one thing that I have observed over the last few years. Financial advisors, and I know we have financial advisors on this call. These are wonderful people who are providing very high levels of service. But one of the things we want to make sure of here is that on the death of someone, when a trust account is being established, that the financial advisor and the attorney and the CPA and the trustee are all working together to make sure that everything is happening the way the trust says so. So in other words, we're getting back to the trust. What does the trust actually say? What does the governing instrument actually say? Well, believe it or not, in our haste sometimes to be of service or to provide leading edge kind of service, we see some financial advisors jumping the gun on this a little bit. We see sometimes that the client, through no fault of their own perhaps, at a time of grief or a time of regrouping after someone passes away, is really doing things that are contrary to the trust. We're seeing assets being distributed to clients outright when they were supposed to be held in trust. So again, we just have to have a fundamental thought process that says the trust is really dictating the terms and the provisions of what is supposed to happen. And also, we never want to forget that at a time of just experiencing the passing of a loved one, there is a timeline for tax elections, especially between spouses at the death of a first spouse. So we just want to make sure that as we're working with the financial advisor, that the planning team is working together to get things reestablished the way the trust designs it to be established, and also not to rush on the retitling of assets, because we don't want to retitle assets too soon. We don't want to be way ahead of where we're supposed to be and getting ahead of certain tax elections that need to be made before things are retitled. And of course, as we see at the bottom of this slide, the financial advisor and the trustee working together can fund trusts with assets that have been sold, and now we have cash and other assets that are going to be funded, or the assets can be funded in kind. Someone says, well, I've become a beneficiary of stocks that have been held for generations and I don't want to sell them. Well, those assets can be retitled in kind and so forth. But look at the bottom bullet point here. We want to ensure that inherited assets that are entitled to a step up in basis, entitled to a step up in tax basis, we want to make sure those assets actually get stepped up. And we want to make sure that all of that happens in the time frame that it's supposed to happen, and that we're not jumping ahead again prior to where we're supposed to be or before we're supposed to do certain things. And of course, the financial advisor is in charge of managing the trust portfolio. So as you think about trustees, we want to have someone who understands this. Is my financial advisor communicating with me, which many of them do a wonderful job of, but is the trustee understanding this? And what are the trustees' fiduciary responsibilities here? So many trustees do not understand this responsibility. And I think the first thing that your selected trustee needs to understand is what are the needs of the beneficiary, meeting with the financial advisor, making sure they understand the tax aspects of the trust, making sure that the financial advisor understands the needs of the trustee and their fiduciary duty, and what does the trustee want to obtain from the trust advisor or the financial advisor. Well, they want to obtain something called an investment policy statement. An investment policy statement saying, financial advisor and financial advisory firm, I'm a fiduciary. I have a certain fiduciary responsibility to the trust and to the beneficiary, and your investment policy statement says you understand that fiduciary duty and that you are investing the trust assets as a fiduciary, and that we are communicating in the best interest of the beneficiary. So for example, that can be very, very important at times like these, when we have volatility in the market and the trustee needs to make sure that they're carrying out their fiduciary duty. Now, I've often told Jeff that we need to find pictures, photographs of the perfect trustee so we could put it on this slide. And of course, Jeff is still searching for that person because none of us are perfect. But ideally, this is what we want to understand. We want to understand what the trustee's duties are as we look at these concentric circles. So the trustee wants to have ability to provide accounting. They want to keep accurate records. They want to make sure that the beneficiaries are informed and they are complying, the trustee is complying with statutory duties. Now, does this mean that the trustee has to do the accounting themselves? The answer is no. The trustee could hire an accountant or a bookkeeper or an attorney to keep this accounting for them. Of course, to the extent that the trustee does it themselves, they'll be minimizing the cost to the trust. And that's an important thing as well, to try to minimize expense to the trust. But look at the other circle here on the right. The trustee needs to understand, not necessarily do the investing, but understand the basics of financial investments, understand their relationship with the financial advisor, understand taxes and working with the professionals. The thing here that I'm really pointing out is that the trustee has the ability to hire professionals. We want to make sure the trustee understands that and that this is not something they have to do themselves. And of course, they have to be prudent, but they do want to hire professionals, generally speaking. And they want to advocate for the beneficiary, just like a couple of slides ago. We want that trustee to understand the needs of the beneficiary, communicate with them, and of course, with regard to whatever that beneficiary situation is. If it's a high-functioning, successful beneficiary that simply has asset protection because of their trust, the trustee needs to understand that and act accordingly. If it's a special needs beneficiary or a person with issues, life issues of whatever kind, the trustee needs to understand that. Now, what will help a trustee is a memorandum of intent. So as you think through trustee selection, I want you to also be thinking about your own estate planning. Now, if you're a trustee on the call this morning and you're saying, well, gosh, I just want to understand more about my duties, then this may not help you if you don't already have this in place. But if you're a person on the call that's contemplating your own estate planning, contemplating the changes to your plan or who's going to be my trustee, I want you to think in terms of a memorandum of intent. If you are a special needs parent, for example, I would want you to consider including a memorandum of intent with your trust, something that can be attached to the back of the trust. If you are a person who does not have beneficiaries with disabilities, but you simply want to articulate your goals, values, and so forth, we could use a letter of wishes. And Jeff is very good at sending out tools that you can use. And one of those things that we can happily provide you today is a letter of intent. Now, what does this have to do with trustee selection? It has a lot to do with it because we want to not only think carefully about who your trustee is and the kind of responsibilities they have, so you're making the right selection, but we also want to guide the trustee. We want to say to ourselves, is this trustee the trustee that's going to read my letter of wishes and understand what I really mean here when I'm saying, well, my trustee should advocate, my trustee should promote the best interest of the beneficiary, my trustee should have certain attitudes toward their financial advisor that I would like them to use, and so forth. So a letter of wishes or memorandum of intent, depending on what our situation is a really powerful tool that will customize the trust that you're thinking about if you are still in the process of your own estate planning. And it also can be of great benefit to the trustee to give them guidance about how to deal with the trust. So why is trustee selection so important? Well, there are many, many reasons, and some of these are going to be very, very personal to you that have nothing to do with this presentation, but trust can last forever. So around the year 2000, 2001, Maryland abolished the rule against perpetuities, which basically said trusts, according to the old English laws, could only last a certain period of time. Well, that is no longer the case. Trusts can literally last forever. And for many of you on the call here this morning, or for your clients, clients are making, or individuals have made vast fortunes over the last several years. We have more assets today than we've ever had for many clients in retirement plans and other things that can be left to trusts, and these trusts can last forever. Trusts are more portable that is, than ever. A trust could be in this state today and be in this other state tomorrow. A trust could be in this state today and be decanted, which we're going to talk about here in just a few minutes, in another state. Beneficiaries live in other states. Many of you have children, grandchildren, and so forth that live in all around the country or all around the world. States are in competition for trusts. So there are trust states, so to speak. There are states like Delaware and Nevada and Alaska and South Dakota that have, I would say, more exotic or aggressive laws than Maryland does about trusts, and the types of trust that can be established in those states are different than the types of trust that can be established here in many circumstances. Trustees have a lot of options. They can serve or they can refuse to serve. Those of you who have met with me before know that I will talk about these issues. I will talk about the fact that we have to be very careful about our trustee selection, because trustees can actually disappoint. They can refuse to serve. Now, there are situations where the trustee has something going on in their own lives with their own health and so forth, and they can't serve. And I'm talking about circumstances where a corporation or an individual refuses to serve. So that's why selection is so important, and having flexibility, as we look at the last bullet point here, flexibility built in for these changing circumstances. I can't tell you how many times in the last 10 or 12 years I've seen, or last 20 years, that I've seen circumstances where if there was more flexibility in that particular circumstance, then we would be able to get from point A to point B and solve problems. But in those particular circumstances, we were not able to necessarily solve problems, and we had to settle for a lesser outcome. Now, decanting is the ability to actually change a current trust or an existing trust from one form to another completely, not just amending a trust like a trust protector power, but to actually change a trust from one trust to another. So trust decanting can be a very powerful tool, but it also can be a very scary tool. So we want to make sure that we are selecting trustees who are going to act in our best interests as fiduciaries, carry out our intentions, that they should generally understand all the concepts we've talked about so far, and that you have confidence in them. But even though you love them and you have confidence in them and you have absolute belief in them, we have to provide for flexibility for changing circumstances in the world today. So the trustee selection process could be very easy. You have a mental checklist, you have children or siblings or other relatives, but I want you to just take the few moments here today or after today, and I want you to weigh the difference between interested trustees, meaning your family members basically, versus independent trustees. So there are reasons that are beyond today's discussion why we would think in terms of interested trustees versus independent trustees. One of those reasons is asset protection. Asset protection is one of the reasons that many of us leave assets in further trust for our loved ones. Not always just asset protection. Sometimes it's just for control. But with asset protection issues, independent trustees are generally going to provide more asset protection for the beneficiary, depending on how the trust is drafted overall. But many times clients want to use interested trustees. So we just need to have a healthy awareness, okay? And this trustee selection process many times is good to educate yourself like you are today and use this presentation as a tool and a substantive tool for future reference. But sometimes this is best done during a review session. So we're sitting here, for example, I'm in conference room number 1 here at Elville and Associates, and we have all of our tools here. We have the electronic whiteboard. We have lots of places to spread out here. And sometimes this is just best done as we lay everything out, talk about all the family issues, talk about all your personal goals, and we discuss this during a process of several meetings. We give you, let's say, the time to think about these things, and they're very personal, and your trustee selections are going to have ramifications. We just want to stay on that straight and narrow path that our trustees are ultimately going to get us to where we want to be. They're going to honor our wishes and the nuances of our estate planning, and we've built in flexibility for changing circumstances. We want to consider conflicts between trustees. So, for example, we always want to be thinking, is this a good idea for these siblings to be serving together or to be successors to one another? Will these siblings be able to get along, or are we really creating a conflict? And remember, in conflict situations, those conflicts can either be resolved or not. And if they're resolved, they can be resolved by cooler heads prevailing, or it can be resolved by mediation or so forth. But many times they can't be resolved. And what could that lead to? It could lead to litigation. And what do we know about litigation? It tears families apart, and it can cost lots and lots of money. So we don't want that. We want to think about how can we avoid conflicts, and how can we structure trustees in such a way that we're going to be able to avoid those conflicts. And that again may lead to a discussion, it may, about having independent trustees. So we would have maybe an individual person who is an independent person versus a corporate trustee who is an independent entity, okay? And there are advantages and disadvantages of corporate trustees versus individual independent trustees, or interested trustees versus independent trustees. In other words, talking about that issue again. And all of these things are the pros and cons of trustee selection, with, in the back of your mind, all of the things that we've talked about prior to these last several slides. All of the things that comprise the framework, the mental framework, and the ability of a trustee to carry out your intentions. Now, let's talk about trust protectors for just a moment. Maryland, since 2014, calls this the trust advisor. But we at Elville and Associates and many advanced estate planning firms have been using trust protectors, which is basically the same concept, which have been around in the United States, I would say, for the last 20 years, this concept. The trust protector is a special fiduciary. And depending on who you are, you may have a different view or a different definition of a trust protector. But in my view, the trust protector is a special fiduciary who has the right to direct the trustee to do something. Typically, a trust protector has the right to remove and replace trustees. That's a big power, remove and replace trustees. And the trust protector might be given the power, usually is, to amend the trust administratively, to amend for tax reasons, or to amend for an ambiguity in the trust, or the changes in the laws have occurred and the trust needs to be amended. So trust protectors provide that flexibility that I've been talking about. It's not only the trust protector that provides that flexibility. The overall plan design can provide that flexibility. Powers of attorney, which are beyond today's discussion, they provide flexibility. But a trust protector provision, generally speaking, is the one that we're really looking for to give you or give the trust that kind of flexibility. So trust protectors and the overall design is what we need and what we want to think about. And in context of the trustee selection process, to understand, okay, here's our trustee. do we give the trust protector the right to remove this trustee if they're not doing a good job, if this trustee is not well? Okay. Well, yes, that's what we would normally say, because the trust protector is a fiduciary and the trust protector must act at a very high level. They can't just remove a trustee if they don't like them personally. They have to have a good reason why the trust protector is not doing their job to protect the trust. But we also want to make sure that the trust protector is just generally part of that design, okay? And we can give the trust protector as many powers as we want. We also could provide a way for the trust protector to be removed by the beneficiaries. So not just the trust protector removing the trustees, but the trust protector himself or herself being able to be removed by the beneficiary. So the trust protector, in my view, is an essential flexibility tool, but it's also something as you think about trustee selection, that you consider how much power the the trust protector should have, and whether or not the beneficiaries of the trust or another person have the ability to remove the trust protector themselves. We talked a little bit about interested trustees versus independent trustees, and this is going to mean a discussion, a further discussion about different standards of distribution, different points of view, different levels of objectivity, okay, different levels of experience, I should say, different levels of oversight, okay, how much do we want this trustee to be involved in certain things, and different practical considerations. So it's a broad discussion of this particular subject, and I'm going to try to make sense of it here. Depending on who the interested trustee is, let's say we have a sibling of yours, or let's say it's a parent of yours, or let's say it's a cousin of yours, someone who is a relatively interested person, okay? This person is going to have different levels of experience and objectivity versus professional trustees, okay? Independent individuals or independent corporate trustees. So this is a discussion of what I would simply call design. As you think through the issues of trustee selection, you're going to be also thinking about design. You're going to be thinking about the qualification of your own particular trustees. And if you decide about independent trustees, we're going to be looking to interview them and really understand how do they deal with beneficiaries and whether this particular trustee for fees and other considerations is going to meet your requirements. So we talked about the trust protector just a few moments ago, and we were talking about some of their powers. But before I continue on through the latter part or the last part of the presentation, I just want to check with Jeff. Jeff, I don't see our chat box, but does anyone have a question?
Thanks, Steve. We do have a couple of questions, and I'll go ahead and pose them to you now. So the first question we have here is, why would a state allow dynasty trusts? I understand, if I can get back to the question here, I understand why an individual might want one, but wouldn't a state government want there to be a time limit on any trust?
Thank you for that wonderful question. I think this is a question of public policy and the state's interest. I think that's a wonderful question. Under the old common law, trusts could not last more than a certain period of time, the rule against perpetuities, which we all studied in law school. Maryland abolished a rule against perpetuities, and many states have. Now, there have been some discussions. So, for example, the one that comes to mind from 2021 is Senator Sanders and others suggesting that dynasty trusts, or trusts that can last forever, that they be limited, not necessarily in the amount of time that they can last, but that they be limited as far as the tax benefits that they provide for generation skipping tax and estate tax. And I think Senator Sanders, even though it never went anywhere, I think Senator Sanders had proposed that certain benefits of trust could not last more than 70 years. And I think Senator Wyden and others have talked about the tax ramifications of allowing wealthy individuals to, maintain dynasty trusts into perpetuity. And this is always a question of, again, the wealth distribution and all of those things that under the old English law, they didn't want dynasties to proliferate. But it's a great question. I don't have a good answer for you other than in many states, public policy has been to remove these limitations. And I know that politically they continue to be discussed. And all of the massive tax, most of the massive tax proposals of 2021 did not go anywhere and fizzled as of the end of the year in 2021. But we may see other things like this again in the future. I hope that's at least a good discussion answer to your question.
Thank you. And one more, and this person was thinking a little bit ahead. So I think you answered the question, but I'll pose it to you. Who will supervise the trustee doing his or her job well?
Thank you very much. That is the exact reason that trust protectors exist in the world today. My simple-minded view of trust protectors is that we had millions of trusts. They become irrevocable, of course, at a certain point or at a certain juncture, and that there were no ways of changing those trusts. Believe it or not, in some trusts, as recent as 10 or 12 years ago, there were provisions that said a trustee could change the trust. And that today just makes no sense at all, especially in special needs trusts. We would see provisions where a trustee could actually change the trust because there was no such thing as a trust protector. But the whole idea of oversight of a trustee is a question of the beneficiary's rights to see information and to provide and to view an accounting. So let's pretend there's no trust protector. Well, then to me, this is a question of beneficiary education. So if the beneficiary understands their rights under a trust, they would understand that they have the right to information, the right to notice, and the right to an accounting under the Maryland Trust Act. So if we have a trustee that's not providing an annual accounting, and I've seen all kinds of reasons for this recently. Oh, well, no one requested it, so I didn't do an accounting. Or, oh, it's going to cost too much. It just costs the trust money if we have to do these accountings. So the problem there is that there is no accounting. So the qualified beneficiary has the right to say, I would like to see an accounting, and I think the trustee has an obligation as the highest and best practice to provide that accounting. So the first way of holding the trustee responsible is to make sure that there's annual accountings and that they are being reviewed. If there is a beneficiary that doesn't have the ability to review their own accounting, then I think the trust protector should be given the power, as you see here at the bottom bullet point of this particular slide, the trust protector would be given the power to compel an accounting. So who monitors a trustee? I would say the beneficiaries by way of being able to see an annual accounting or demanding information. Secondly, a co-trustee. If there is a co-trustee, that means these trustees have to be accountable to one another. And then through a trust protector provision, with the trustee knowing that if they don't do a good job, the trust protector can remove them. I think those are the formal or informal ways of monitoring a trustee's behavior. And of course, if a trustee refuses to account, I believe easily the qualified beneficiaries can take them to court by way of petition and demand an accounting and even the potential removal of the trustee.
Okay, thank you. We do have a couple more. I'd like to maybe get those in here.
Go ahead,
Interesting question here. Good morning. So far, I have not heard circumstances where there is a power of attorney of a disabled adult as it relates to a very poorly drafted special needs trust. The trustee, who is the nephew, has not distributed the assets into the trust in 3 years. What power does the power of attorney have against the trustee?
Well, thank you for that question. That sounds like a very fact-specific question that I would have to see more of or talk to you in person, and I'm happy to help there. It sounds like, and of course this cannot be legal advice because I don't even know the facts or circumstances, and there's no relationship here with us as far as a legal relationship. But just based on the limited information that I've heard, it sounds like the person who passed away, for example, they intended for assets to go into a special needs trust, and that has not happened. It sounds like the trustee, who is the administrative trustee, has not funded that special needs trust. And when you're saying a power of attorney, I'm assuming the power of attorney of the person who died, of course, that power of attorney is no longer effective. So I think my inclination is to say it sounds like the interested parties of that estate or trust would need to compel the current trustee to fund that special needs trust and get the administration done if it hasn't already been done. So that's what it sounds like, and I'm happy to talk to you more about that.
Thank you. And last one, if you have more than one trustee, can you state an order of preference for who should control the trust?
Yes, so you have various options about how you structure trustees. So not only the selection of a trustee, but the order of the trustee. Should I have someone serving with me? If I have a revocable trust, I'm normally the trustee of my own trust. So should I have someone serving with me as a co-trustee during my life? Or no, at my incapacity or death, there will be a successor trustee and then another successor in that order. Or should I have co-trustees serving together? And if I have co-trustees serving together, can they act alone? Sometimes clients want trustees to be able to act unilaterally, and those are all based on the circumstances of a particular situation. So yes, you can control not only who the trustee is, but who is the order of trustees and how they have to act in that order, together or not.
Okay, great. Thank you. And thank you for the questions.
Yes, thank you very much. All right, as we continue now toward the latter part of the presentation, remember the role of a trust protector is basically this. They are a special fiduciary. They are appointed under the law since 2014. And even before the new law, Elville and Associates and many advanced estate planning firms used the concept of a trust protector, which comes from other states, advanced planning states like Delaware, Nevada, Alaska, South Dakota, and other states. The trust protector basically has a power of amendment and directing the trustee, but the trust protector can remove or replace trustees. They can mediate disputes. They can compel accountings, just like we talked about a few moments ago. And the idea here is to be able to amend. The idea is to be able to be flexible, building flexibility into a future plan. Just like the person's question a few moments ago about trust lasting forever. Remember that forever is a very long time when it comes to trusts. So we want to, ideally, even though it's not required, we want to use a trust protector if we can visualize that concept, as long as we feel comfortable with having third parties involved, arm's length individuals, arm's length independent individuals who could actually make changes to the trust in your best interest as a fiduciary. Now, in wills, if we can visualize this, there can be trustees of different trusts under a will. So a will is not a trust, right? A will is an instrument. It is a testamentary instrument, but let's pretend the person who is the testator of a will dies. They can establish a bypass trust. These are the normal modern terminology for trusts for spouses, or a marital trust. So that's a role that a trustee would play, a trustee of a bypass trust or marital trust. Under a will, a trust for young persons, a person's under 30 or 25 or whatever age the testator sets under a will. The trustee of their own trust. Let's pretend a person dies and leaves a beneficiary a trust. They leave a trust for that beneficiary's protection. That beneficiary can be the trustee of their own trust in Maryland. Now, that may or may not be a good idea. That's a whole discussion in and of itself. Should we have a person who is an interested person, remember, in their own trust, should we have that person as the trustee of their own trust or not? Trustee of a trust of another person who has been left a trust. So in other words, The third party, who is the trustee of another person who has a protective trust to protect them from themselves or from divorce or from bankruptcy and so forth. Now, in a revocable living trust, which is what? A substitute for a will. That's what it is. A trustee of a revocable trust, there are similar roles, but different. So here, the trustee of the living trust, the trustee of the revocable trust is you, for example. And this would be you during your lifetime, or if you were incapacitated, then your successor trustees would step in. Or you have died and your living trust now needs to be administered. This is one of the biggest questions people have around the world about estate planning. What happens to my living trust, my revocable trust, when I die? Well, my revocable trust becomes irrevocable, and now it has to be administered. So you are the trustee of your trust during your life, your revocable trust. Your successor trustee takes over on your incapacity or death. And now your revocable trust has become irrevocable at your death, and it has to be administered, and the trustee has to administer the trust. Now, bypass or marital trust can be created for spouses. So a trustee has to be appointed for those trusts, same as a will. Trustees for trusts for young beneficiaries. Trustees for a spendthrift trust for yourself. If you were left a trust by someone, or you were someone leaving a trust for someone else, you could be the trustee of your own trust, or that beneficiary can be the trustee of their own trust, just like we saw in a will situation. Or we could be the trustee of another trust for another individual. We would be third-party trustees for another person who received a trust under a revocable trust. After that revocable trust was administered, it was distributed to the further beneficiaries in trust, and now that third party is the trustee of that trust. Now, as we move towards the latter part or the end of our presentation, what reason is there to appoint a corporate trustee? Well, we talked about independent versus not independent trustees, independent versus interested trustees. Here we're talking about an independent trustee, but not only that, a corporate trustee, such as Truist, a corporate trustee such as Navy Federal's member trust company, a corporate trustee like Vanguard, a corporate trustee like Charles Schwab or Sandy Spring Bank, or on with corporate trustees. Experience could be one reason. Asset management. Many times a client or a potential client will say, I want the experience of a corporate trustee. I want them to manage assets. And by the way, that might actually be a good deal. They are actually operating as a fiduciary and managing the trust, but they're also managing the assets. So I feel that the fees are justified. They are regulated by state and federal government. They are generally considered to be reliable, although many people are concerned about fees. And my advice is to really interview several corporate trustees if we are concerned about the possibility of using them. We always want to keep in mind that we have to have flexibility for the long term. What if a corporate trustee no longer exists in the future? What if they're purchased by another corporation or a bank? What if they refuse to serve because at the time of your passing, they don't like your portfolio? And I've actually seen this happen. That can be discouraging, but the idea of the trust protector resolves that problem because a new trustee could be appointed. They're objective. They can manage my particular situation, someone might say. They are a source of resources. They are a great referral hub. They can direct my beneficiaries and provide resources to them. And it gives me peace of mind. So there are various things for various types of individuals to consider and families to consider about a corporate trustee versus a non-corporate trustee. And why should we be concerned about the concept I mentioned way in the beginning here about successor trustee risk? What is successor trustee risk? Why am I talking about this? Well, this goes back to the same concept of the need for flexibility. We've got trusts that are out there, millions of them. We have trusts that become irrevocable. We have trusts that have no flexibility because there's no trust protector. We have trust that lasts forever. Trust that forever might mean 50 years. It might mean 30 years. It might mean 200 years. So what is the risk? Well, the risk is that the persons or organizations that we have named as our trustees, for example, individuals are experiencing age-related issues. Are they experienced? Do they have experience over time? What is their health or health deterioration? Most of the time, we are not requiring a bond because what do we know about a bond? Well, most trusts excuse the trustee from posting bond. Why is that? Well, because bonds are expensive. I saw a trust recently where a bond was going to cost about $27,000 a year just to make sure the trustee was bonded. So most trusts do not require a bond, but now over a long period of time is the trust at risk due to the actions of a trustee. So there's risk there with who the successors are going to be. Other life changes. Are the trustees divorced? Are they having issues in their own lives? Issues that are unforeseen. We wouldn't have appointed these people if we knew they had issues, but these are things that happen in life. What if they get disconnected with the beneficiary? What if they're not communicating with the beneficiary? What if they don't even know where the beneficiary lives because the beneficiary has moved and the beneficiary has failed to keep in touch with them, which probably won't happen. But what if these disconnection issues happen? What if the beneficiary is extremely demanding? What if the beneficiary is so demanding and so unreasonable that the trustee refuses to serve and all trustees refuse to serve? This can happen. Usually doesn't, but it can happen. What is the trustee's willingness to serve? What is their fortitude and perseverance? Is this a person or organization that you can really rely on? And have you provided for the right trustee compensation? Under Maryland law, trusts can provide for statutory compensation, which is very limited. So most modern trusts provide for what is called reasonable compensation so that it doesn't discourage trustees from serving. So all of these things are what I would just throw out, not to worry you, but to raise valid issues about the long term. Are there risks with trustee succession? Now, how can you overcome some of this risk? Well, I think the best way to overcome this risk is to constantly look at your estate plan. And here's what I mean by that. Jeff had mentioned our client care program. Our client care program is really designed for one major thing, two maybe. The first one is to make sure that trusts and wills and so forth, that estate planning works the way it's supposed to. But what is the client care program really about? It's about encouraging clients to update. That's really what it's about. And many of you are concerned right now. World events, the markets, COVID-19, as we continue to hopefully get past all of that, you have a lot on your minds. We all do, and we understand that. So all you can do is, with your estate plan, is be diligent. You're here today. You're a student of information. You have spent your valuable time today looking and listening at this presentation and participating, which we really appreciate. But what I want to encourage you here to reduce the risks is really to systematically and continuously update your estate plan every year, or at the most every 2 years, if for no other reason than just to have a conversation. Here's how things are going with my family, with my beneficiaries, with my situation. Here's how I feel about my trustees, what's going on in their lives. If you do this consistently throughout the rest of your life, and you build in a reasonable amount, if not a robust amount, of flexibility, that is all you can really do, and take advantage of the leading edge techniques that are available in the law, understanding that we have to be reasonable with these things. We don't want to just do foolish things, but we want to build in flexibility. And if you do this maintenance and updating during your lifetime, make sure your trust is fully funded to the greatest degree possible. Make sure you've done all of your due diligence. do your continuous maintenance and updating, and provide flexibility. That is all you can do. And I think you can say to yourself that you've done a good job. You've done a job well done with your trustee selection process and thought process. So Jeff, I'm going to wrap up here. It's about 11:15. We've been going for about an hour and 15 minutes. I want to thank this wonderful audience for their questions and their time and their attention. And I'm going to just end it and let you take over for final questions and wrap up.
Well, thank you very much, Steve. As always, a really important topic and something that requires a lot of thoughts and counseling, and that's something that we do here at the firm. Is Steve and I always talk about is giving clients time to think through issues, and that's all part of the planning process here at Elville and Associates. So we do have some questions, and now would be your time to get those final questions in for Steve as we wrap up here in the next few minutes. So I will go through the few questions that we do have here. The first one we have here is, where can we find an independent trustee?
Thank you. The answer to that is it's going to depend on your family circumstances with regard to individual independent trustees. So the first thing I would do is look around you and look at trusted friends, people that are arm's length from you, people that are not family members, people you go to church with, people you work with, people that are have been your longtime associates, and these people are very high standing and personal responsibility. That's where I would start to look. Also, I would look at, where do I do my banking? Where do I do my investing? If I have a financial advisor, which I hope you do, and you really love this person, you want them to continue to be involved, then the first thing I would do is look to their underlying trustee relationship that they have through their broker dealer. And this could be a very rich source of where to start to be able to have the confidence of an independent trustee by also staying with your financial advisor that you have such a wonderful relationship with. Attorneys and CPAs also serve as independent trustees. Here at Elville and Associates, we have our Waypoint Trust Group, which is basically our trade name for ourselves acting as independent trustees. So you have many different choices out there. That's where I would start.
Okay, thank you. Next question, how many trustee backups do you usually recommend if a trust is to last possibly 70 to 80 years?
Wonderful question. I would say I would want to see a successor trustee and probably 2 backups. Now, this is not scientific and every situation is different, but I would say if you know who your primary successor trustee is and you have 2 other backups, that is a great situation. Now, everybody's different. Some people would say, I've got 2 backups, or I've only got 1 backup, or I've got 3 backups, and after that, I have a corporate fiduciary in there. Just to make sure I've covered all my bases. And on top of that, I have a trust protector. So I think it's all what is reasonable, and it's all based on how it feels, because a lot of estate planning is legal technical, but a lot of it is also very personal to you. So I would say ideally a 1 successor plus 2 backups in addition. And this is also going to depend on whether you use individuals or a corporate fiduciary.
Okay. And 2 questions related to trust protectors. I'll roll them into one. Who appoints a trust protector? And secondly, who can play the role of a trust protector?
Thank you for that wonderful question. So the answer is that the grantor of a trust chooses the trust protector. And in certain circumstances, the trust will say that if the trust protector is serving, but there is no other trust protector after that person, that perhaps the trust protector has the right to choose a new or successor trust protector. So it's generally the grantor. And in today's world, the way that our world looks right now in the law, trust protectors are generally not corporations. They are individuals, and they should be, they're not always, but they should be, in theory, always an independent person, a person who is arm's length from the family. So a friend, someone that is a person of high confidence that understands you and your family and your goals, or it can be your attorney, it can be a CPA. It does not have to be an attorney, but many times attorneys serve as trust protectors. But again, any independent person, usually not a corporation, because corporations will not serve as trust protectors. I have seen recently several financial advisors that say they can serve as a trust protector. So that's going to depend on their various circumstances, but it's an individual who is independent from you. And I know this creates another design feature that you have to think through, but it's going to be an individual, not a corporation.
Okay. Next question. In the case of a marital trust, specifically aging parents, where one of the trustees has now passed away, what are your thoughts on co-trustees, adult children, to support the survivor trustee who is not financially savvy to manage accounts?
Thank you. My initial thought on that question is, I'm assuming you mean the surviving spouse is one of the trustees, and the surviving spouse needs help in managing those accounts. I think that's a wonderful arrangement, because not only does it help the surviving spouse in managing exactly along the lines of what you've said, but it also helps accomplish one of the intentions of the marital trust, which may or may not have anything to do with your question. But remember, a marital trust is really an asset protection mechanism. So it protects the surviving spouse, but it also protects the deceased spouse and the future beneficiaries after the death of the surviving spouse from the claims of a new spouse, and to make sure that the assets generally go down to the family members in the way that the deceased spouse wanted them to. So long story short here, by having additional co-trustees to support the trustee, the sole trustee of the marital trust, you are also ensuring that the marital trust will not be depleted, and it will, unless it's needed to be depleted, it won't be inadvertently depleted, and it will go down as it's supposed to the children after the death of the surviving spouse.
Okay. Next question, can you offer general information? I'm sorry, understanding you are unable to answer specifics of my legal matter as a POA, can you offer general information as it relates to the roles and responsibilities of the power of attorney with respect to a disabled adult?
Excellent question. So if a disabled adult has who we will call the principal, the person who signed, apparently they have a mental capacity, let's say, to sign a power of attorney, even though they're disabled. So let's say that high functioning disabled person has a power of attorney, then they have given you authority to act for them. And that's going to depend on the terms and conditions of that power of attorney, whether it's effective immediately or not, whether it's effective only upon the disability or the proof of incapacity, I should say, of the disabled person. So a lot of that's going to depend on the terms and provisions of the power of attorney, but the fiduciary responsibility, depending on when your power is effective, your fiduciary responsibility is the same basically as a trustee almost. You're responsible for accounting to the beneficiary, to take care of them, to pay their bills, and to basically account for all of their financial affairs if it's a financial power of attorney.
Okay. This is a very extensive question here, so I will try to get through it. It might be very fact specific. This will sound very familiar from touching on this yesterday. Can you please comment on the possible ways or options to, in the interest of the beneficiary, to overcome a general power of appointment that was included in a 2021 revocable trust that, due to the death, is now an irrevocable trust, specifically to not have assets of that irrevocable trust be included in the estate of a family member who recently passed? Because if the assets of that trust are included in the family member's estate, it will trigger a large estate tax. Was just wondering how a trust protector could possibly overcome this general power of appointment, or if a non-judicial settlement could overcome this, or what other possible ways could this be accomplished? Thank you very much.
Hi, I am familiar with this particular issue, and I thank you for your question. If I'm understanding you, the answer would be no, and I think we had covered this a little bit before, so won't be able to talk about that any further now, but I think the answer is generally no, that there's no way to overcome that. It's just an answer to your question.
Okay. What is the difference between a first and third party trust? Is there a second?
Thank you for that question. I believe you're referring to special needs planning. So in special needs planning, the first party trust, as we call it, is the assets of the disabled person. The disabled person who has actually received assets that they should not receive because they will do harm to the person's benefits. So that person's money, if they are under 65, can be put into a certain kind of first party trust to protect it for Medicaid purposes and public benefit purposes. If the person is over 65, it can be put into a different kind of first party trust with the same concept. A third party trust is when someone establishes a supplemental needs trust for the benefit of a disabled person. So a third party, like a parent, sibling, grandparent, establishes a trust for the benefit of a third person who is disabled, and that trust does not have a payback to Maryland, and that trust does not have to be approved by the state of Maryland. The first party trust, because it's the person's own money, that has to be approved by Maryland, and there is a payback to the state of Maryland, generally speaking, with that trust. So that's the two differences.
Okay. And last question. Since the grantor has died, can a beneficiary who is also a co-trustee select a trust protector?
Well, that's a great question. That's going to depend on the terms and conditions of that will or trust, and it's going to depend on how much flexibility was built in and whether or not it is contemplated in there for a trust protector to exist at all. So there are some circumstances where trust, even after death, can be amended to include certain flexibility provisions, but it may or may not be possible depending on how it's drafted. Thank you for that question.
Okay, very good. So those are all of our questions. Thank you for the great questions. We appreciate it. Really adds to the presentation. We're going to go ahead and wrap up now. I'll do a couple things as I always try to do. I send out a email with some substantive information including the video from today as well to share with anybody you feel would benefit from the information we talked about today. I'll send out a copy of our letter of intent, as Steve alluded to as well. Also some information about our client care program as well. As far as our webinar series, we're staying busy in March. Next Tuesday, we have our wellness series, Keeping Your Brain Active and Healthy. On Friday, the 18th, we're going to have Steve talking about what families need to know about planning for a loved one with special needs. And also Tuesday, the 22nd, piggybacking on yesterday's very popular financial exploitation, frauds, and scams presentation by Mr. Andre Lingham. We're going to be talking about identity theft, the illusion of privacy, also again with Mr. Lingham, which was extremely popular and well received. So looking forward to those upcoming webinars. Invitations have been sent out for all of them. You can also register on our website. So again, thank you, Steve. Thank you to all of our attendees for being here today and participating.
And Jeff, I just wanted to insert one thing here. I did get a sense in this particular webinar today that there are many people with questions and issues. I just want to make sure that we give them a path forward to set an appointment and that we cover that real quickly as we wrap up. And I know we want to end on time.
Yeah, absolutely. There's many ways that you can set an appointment here at Elville and Associates. Through the post-webinar feedback, you're always welcome to let us know if you'd like to set an appointment. It's very easy to do. We can have Mary Gay Kramer, our executive assistant for Steve, reach out to you to set a time. You can reach out to me very easily, as always, jeff@elvilleassociates.com. And here at Elville Associates, many of our consultations for estate planning are free. Hour to hour and a half typically with Steve to talk about your issues and your specific situation. He'll listen to you, work to create a path forward and create some solutions to your needs. So that's a very important aspect of what we do here at the firm. So all consultations for those are typically free. So we look forward to being a resource to you here as always, always giving you time to think about your situation and counsel, educate, as we always do here at the firm. So let us know how we can be a resource to you, and we'll be happy to serve you in that manner. So we appreciate you being here today, as always, and we look forward to hosting you again soon. So thank you for your interest in our webinar series and Elville and Associates. Thanks.